honorable members. Morning, Minister and their team. Morning, the team of the IEC, the Parliamentary Legal Service in attendance, and all our colleagues. We want to welcome you again to the Portfolio Committee meeting. As you know that we had postponed or rescheduled our committee meetings on several occasions due to the budget votes that were engaged on in Parliament, particularly security cluster, where Home Affairs located, and most of the budget votes in security cluster were being conducted on Tuesday and Fridays. So all members of the committee ought to attend this budget vote. So we could not have this portfolio committee on those days. And I want to apologize for that delay. It was not our deliberate. We are also meeting here since the minister has presented his introduced the consequential amendments on the party funding and related insertions, and also the framework to deal with the political party funding, which we had noted and agreed that we'll come back and deliberate on it so that we take it for a process. We're also going to interface with the matter that relates to the processing of the bills in relation to all the consequential amendment that has to be taken by the committee, and the decision as item number 5 outlines, so that we're able to proceed with the speed on the matters that have been engaged on. The chair has already engaged with the Parliamentary Legal Service and also interacted with the minister in terms of some of the issues that were outstanding for the committee to consider and deliberate on. The IEC also had indicated in some of the consequential amendment that they ought to be brought to the attention of the committee. What is important is to work on the time frame so that we're able to come closer to the issues and report back to Parliament in terms of the bill that the Parliament must consider, so that you allow the IEC also to deal with its own internal process. Our agenda, members, is as highlighted, will reflect on the matter that was presented in our last committee meeting. But before that, I will request Honorable Mr. Matonsi to render apologies and introduction of members in attendance, and then we'll then go to the item as outlined. Mr. Matonsi?
Yes, Chairperson, from my side, I've got only one apology, that of Ms. Kanyile. She's attending another meeting.
Okay. Can you introduce members who are in attendance? I know other members, Minister, no apology.
Chairperson?
Yes.
I'm very sorry to interject, Chairperson. Unfortunately, I won't be able to stay too long. I've got another portfolio committee and also a constituency meeting. So I will be departing by around 10 o'clock. I just want that to be noted. My apologies.
Noted. Honorable van der Merwe. Minister? Deputy Minister?
Thank you, Chairperson. We are all here. I think that the minister might just be experiencing some connection problems. We do have the DG with us here today, and as well as the staff in the office of the minister and the deputy minister. Thank you very much.
Mr. Matons, do you have IEC?
Yes, the chair of the IEC is in the meeting.
Commissioner Miepza, morning.
Good morning, Chair. Good morning to members of the committee. We are well represented this morning, except for the judge, and the CEO with his team are here. Thank you very much.
Thank you, Commissioner. Parliamentary Legal Service.
Morning, Chairperson. Chalana Ali Starkey, and I am in attendance alone for this meeting.
Okay, noted. All apologies. Deputy Minister, I'm not sure if we can proceed whilst the Minister is struggling, because he has indicated that he's still.
Yeah, if maybe you can just give me a minute so that I can check with him. Thank you.
Thank you, dear.
Chairperson.
Honorable.
Chair, just a thought. Perhaps we can deal with the minutes and then we can get out of the way while we're waiting for Minister.
Okay. Mr. Matonzi.
Okay, Chair.
Can Mr. Salmon take us through on the? Okay. All right. Yeah.
Chairperson.
Can proceed, Mr. Matonzi.
Okay. Yeah, Chairperson. This sets of minutes that we deferred them because there was 2 paragraphs that were supposed to be added. The minutes of the 18th of April, and then I'll just go to where we added the paragraphs. There was an issue which Mr. Ross indicated about the citizenship of the Guptas that they've acquired in Vanuatu. So can I read the red part, Chairperson, so that no members are. Mr. Ross indicated that the issue of the loss of citizenship was at the Supreme Court of Appeal in relation to Section 61 of the South African Citizenship Act. The section says that a South African citizen will cease to be a South African citizen if they apply for another citizenship without first obtaining permission from the Minister of Home Affairs. The Gupta family obtained citizenship in Vanuatu, and Mr. Ross wanted to establish if the family did obtain permission from the Minister of Home Affairs before applying the Vanuatu citizenship. If they did not apply, it means that they automatically lose their South African citizenship. And then Ms. van der Merwe added that that the Gupta family obtained their South African citizenship fraudulently, and now they have acquired the Vanuatu citizenship and cease to be South African citizens. So this is what the member said. And then on the response from the minister responded that the DA is also read in the media about the Gupta family obtaining Vanuatu citizenship. However, the minister did not receive any application to retain their South African citizenship. The minister indicated that it was the position of the department to cancel the Gupta citizenship, but the DA challenged the department in court. The DA was appealing. The DHA was appealing the case at the Supreme Court of Appeal. The case was still pending, still to be heard. And then the minister also responded to Ms. van der Merwe about the Gupta obtaining their South African citizenship fraudulently. He apologized to the committee and South Africans in that he previously indicated the Gupta had obtained their South African citizenship fraudulently. Parliament conducted an inquiry into the matter and did not find that the Gupta family obtained their citizenship fraudulently. The Gupta family were granted early citizenship because the DA said that they were investors, which was not the case. The Gupta family used political power to receive early citizenship by ministerial discretion by the then Minister Gigaba. The Minister of Home Affairs will meet with the Departments of Justice, Correctional Services, and International Relations and Cooperation to discuss the implication of the matter, including acquiring Vanuatu citizenship without asking permission from the Minister of Home Affairs, as well as the implication for extradition. That is that, Chairperson. That's the minutes that we did not adopt on the 16th of May.
And these were the, remember where the committee said you must go and on record on audio.
Yeah, I verified it.
Okay, members, this is the minutes you have requested that you must not adopt for further verification. Can I get comments and invite for adoption?
Chairperson.
Ross?
Chair, perhaps if I can just give my inputs and Eddie goes to the relevant section. So on 7.5. Yeah, I think it's fine in general, and thank you for adding this. It's just, so the section is 6 with the 1 in brackets.
Oh, okay.
And then, you know, just to be technically correct. So it says, the section says that a South African citizen will cease to be a South African citizen if they apply for another citizenship without first obtaining, it's a retention of citizenship. So they don't need permission to apply for another citizenship. They must first apply to retain their South African citizenship. Okay. There is a difference there.
Okay.
Yeah.
Okay. Thanks very much.
They do not apply to retain their
correction. So these are the comments and the response by the minister.
Sorry, Chair. It's just it's still saying if they apply to retain. If they do not apply.
If they do, oh, okay. If
they do not apply.
They not.
Yeah, and then you can take out without first obtaining permission from the minister, because they. Well, yeah, I guess they apply with the minister to retain their citizenship.
So I must take out from first, no? Without.
Yeah. It's just we're not saying that they must apply to the minister to apply for another citizenship. It's only to retain their South African citizenship.
Okay.
If they don't do that first successfully, then they automatically lose it. And then on 8.1.
On the minister's, which one?
Responses by the minister. So firstly, there's 2 8.1s. I think it's just the second one must be renumbered 8.2.
Oh, okay. No, I'll do that.
Okay, so on that second 8.1, which is 8.2, I just wanted to clarify, Eddie, that we're saying here.
Can I assist you, Honorable Ross and Mr. Matons? We requested you to go to the record. And listen to the contributions of Honorable Ross and Honorable Minister Mzwaledi. And if you are now exercising your engagement from that platform, you're amending changing the contribution that you have it was on record. I'm not sure that I'm assisting both of you.
Here, it's just an interpretation of what was said. So you might go back to the record, and they might, so for example, with 8.3, you might listen to the record and then you understand it a certain way, but it's something else. And that's what and these are proposed corrections, Chairperson.
Yeah.
Mr. Matonzi?
Chairperson, it's me.
Honorable Bongo?
No, Chair, I was saying we had commissioned that Mr. Matonzi reads go and check the record, it's a procedure. Now, what Honorable Ross is doing now is amending from what appears to be from a record. And I doubt whether we must just approve those amendments that Honorable Ross is doing out of a recorded something that is there. Not unless we all now see the record. But from what he's doing now is amending from what is his understanding. It's a problem. I think we can't go with this line of amendment from Ross.
Chairperson.
Yes. Honorable Ross.
Chair, this process, every set of these minutes is from a recording of it, surely. So all the minutes we've gone through is to look at the recording and to write down the minutes. So this is no different to any other amendment process.
No.
But I feel if you see the proposal to 8.3, you will understand why it was it was a reasonable misunderstanding, and it's just to correct it.
What we're saying, yes, what we're advising is that there were minutes which were presented by Mr. Matonsi, and those minutes were not accurately captured, and we directed all of us that go back and listen carefully to the recording on the issues that we could not agree on to adopt. Now, that exercise was done and is bringing the matter for us to adopt with clarity that is sourced. So what you are doing, Honorable Ross, is that you are again inputting and amending the minutes that exercise has been conducted thoroughly by Mr. Matonsi. Mr. Matonsi, I'm not sure before Honorable Ross comes in, if we're assisting you proper.
Yeah, no, you are assisting, yeah.
So these minutes reflect how we've contributed by Honorable Ross and the minister, except the corrections that you ought to do.
Yeah, Chair.
Okay.
So Chair, unfortunately, then there's an incorrect statement in 8.3.
Where can we get that?
This process? So, for example, where it says the minister indicated that the position of the department to cancel the Gupta citizenship, but the Democratic Alliance challenged the department in court. We didn't challenge the cancelling of the Gupta citizenship. What the minister was saying, I had referred to he had referred to a court case where we are challenging this thing of automatically losing your citizenship. We didn't challenge the department's decision to cancel Gupta citizenship. So it's just one can watch the recording and perhaps think that that's what was said, but it's not. What I was saying was with the Gupta citizenship, they have lost their citizenship in terms of Section 6(1) of the current Citizenship Act. And then the minister said, the DA is challenging this in court. But when he wasn't saying we're challenging the loss of citizenship of the Guptas, he was saying we are challenging Section 6(1), the constitutionality of it.
Okay.
So that's all. So we're just saying that we're not challenging the cancellation of the Gupta citizenship.
Okay, noted. Noted with that correction, Mr. Matonsi. I think, is there any other matter on the minutes? Mr. Matonsi?
No, then it's right.
No, that was the sections that I was asked to go and listen to.
Okay. Thank you for that, Mr. Matonsi and Honorable Bongani Bongo and Honorable Ross. Can I invite for consideration of the minutes?
Chairperson, I move for the adoption of the minutes as amended.
I will second, Chair.
Thank you, Honorable Van der Merwe. The minutes have been carried of the, what is the date, Mr. Matonsi?
18 April.
18 April. Thank you very much for that. Can we now move to the first item?
Chair, there is another, unless if we're going to, there is another set for the last meeting.
Yeah, let's refer to the next meeting.
Okay, this is the meeting of the 16th May.
I was advising Mr. Matons that let's refer to the
Oh, okay. All right. Okay.
next meeting, the minutes, then we deal with the item on the agenda.
Okay, no problem.
Thank you. We can still use the same process we've dealt with. Next meeting will start at 8:30 to conclude all outstanding minutes. Yeah. Can we now move to the item number 3? Mr. Salmon, I've requested Mr. Matons that we must recap the principle that the minister has requested us to comment on in our last committee meeting when I was introducing the consequential amendments in relation to the political party funding, the framework, and get a sense of how we must interface with it, so that if we approve, then they can start to engage on it in the processing of the consequential amendment. And also the Telena then will come on the issues that relates to the broader consequential amendments, and members will comment on that. And they will then have go to item number 5. Mr.
Thank you,
Simon?
Chair. Yes,
Thank
thank you,
you.
Chair. Eddie, if you can just allow me to share the screen, I can share the document that the department briefed us on. But let me just say in the meantime, the minister provided a policy document that focused on the changing only on the Political Party Funding Act. And the policy document went into the overarching principles of the matter, where including transparency in the party funding, the belief that all parties and independent candidates should have fair access to party funding, maintaining a link between public representatives and the public. International support had to be declared and monitored. That South African and global supporters should be encouraged to donate to the Multi-Party Democracy Fund. Fixing the legislative environment regarding party funding should also help make funding easy, transparent, and democratic. And the amount should be prescribed in the legislation. Let's see, have you enabled? Yeah. So those were the overarching principles. And then the minister kind of they went into the specific limits for reporting of domestic and international donations, and that these guidelines should be the specific guidelines for the amount should be reported on. And then also indicated that the Multi-Party Democracy Fund was an important mechanism for donations, and some aspects regarding how to use that fund. And then highlighted the changes to the formula needed for parties' independence, and this was to ensure that they all receive their fair share. And then the minister also kind of also covered the importance of remaining responsive to public participation, and that if a committee bill were to be drafted, that the amendments were in the interest of securing democracy. There was then the discussion from members indicating that they just needed more advanced notice of the policy documents prior to discussing them, and also that the chairperson advised that the IEC should also brief the committee on its administrative changes required for the electoral act itself, because the chairperson of the commission indicated that they also needed some technical changes to the bill, which they would furbish us with. So that's in essence what was covered in that briefing by the minister. Thank you, Chair.
Okay, thank you very much, members. This is the presentation by the minister, and we're requested to look at it as a framework in relation to the changes that we ought to consider. And this will be the opportunity for members to impress on that. We'll also invite Telana to impress on the process issues, and then we'll then get into the last item. I'll also request Commissioner Mieta to comment, or the Commission, on the possible consequential amendment that you'll be bringing to the committee through the so that we note and we process the framework on how we're going to deal with all the consequential amendments that need to be interacted with by the committee. But I think also Telana will assist us in that on that front. Members, have you interacted with this space? Can I invite or let me invite Telana. Telana, can you deal with this second item so that we deal with two items at once?
Morning, Chair. Would you like me to deal with the discussion around the other consequential amendments? And besides that of political party funding?
Yes, Telana.
Thank you, Chair. Members, at the moment, at present, there hasn't been a decision regarding whether we will proceed with an executive bill or whether we will be proceeding with a committee bill. Currently, in front of us, we have a policy document that has been presented by the Minister that deals primarily with the Political Party Funding Act. However, there are further consequential amendments that would need to be made as a result of the Electoral Act, the current Electoral Act. The first being that of the Electoral Commission Act and Section 5(1)(g), which deals with party liaisons. That would need an amendment to include independent candidates, and this is a direct result of Section 39, 58, 62, 64, and 100 of the Electoral Act. The second amendment would be that of the Electronic Communications Act, and this act provides a regulatory framework regarding electronic communications and networks and provides equitable treatment of political parties for broadcasting during elections. However, there's a lack of inclusivity with regards to independent candidates, and therefore Section 1, 52, 56, 57, 58, and 59 would need to be amended in order to bring parity. The third act would be that of the Financial Management of Parliament and Provincial Legislatures Act. And this act provides at Section 34 for the support of members and political parties, but it does not include independent candidates, and therefore this section of this act would need to be amended. The fourth act would be the Electoral Act in itself. The IEC would be better placed to present this matter, but they have indicated to us that because of the fact that there are two ballot papers for the NA, a regional ballot paper for independent candidates and political parties, and then a national ballot paper for political parties, there seems to be a problem with regards to what do we do with a voter who is voting overseas or voting in a region that is not, they are not registered. So they have proposed an amendment that will consider this problem and address it. Those are the four other consequential amendments that we think necessary as legal services that was lacking in the policy that was presented to the committee. As such, we are willing and able as legal services to provide assistance with whatever choice the committee takes, whether it be proceeding with an executive bill or proceeding with a committee bill. I think that's all, Chair.
Okay, thank you, Telana, for that input. Members, these are the presentation as a result of the introduction of the minister's documents in our last meeting. I will invite you for comments. Honorable Pillay, Honorable Roos, Honorable Bongani, Honorable van der Merwe, Honorable Molekwa, Honorable Mutisemza, on that those issues that were raised. I'll also invite the commission to comment and the minister to comment. Then we'll able to take process forward. Honorable Pillay.
Thank you very much, Chairperson. Thank you, Tilana and Minister and all colleagues. Chair, I think mine is very simple and straightforward. Having already received some kind of input and presentation from the Honorable Minister, I think in light of time, and you know, we are all chasing against time, that we shouldn't then reinvent the wheel. We should allow it to be an executive bill, Chair. That's my proposal. It's an executive bill, and request Minister and his team to include all the other consequential amendments, so that we don't have to start from scratch. Because if we're going to go committee, it means now we're going to have to do everything. But again, we're going to be doing stuff that's already been done. So my proposal, Chair, is that to save time, we'll be able to agree on an executive bill, requesting Minister to include other consequential amendments, and then we can be able to move forward. Thank you, Chair. Oh, sorry, and the presentation we received in terms of the guiding framework, or the framework that was presented, Chair, in principle, all of those issues are quite correctly covered, and I don't think there's a need for us to change any of those frameworks. I think it's just now a matter of the terminology that we use and how we then document that in clause by clause. Thank you very much, Chair.
Thank you, Honorable Pillay. Honorable Roos.
Thank you, Chair. Chair, I've got to be honest, I'm struggling to follow this process 100% clearly. I remember us having a meeting in February where we looked at decision 1, initiate a committee bill or wait for a revised executive bill. And it was said to us that the executive bill was going to take 18 months. It's going to take way too long. And at that stage, my understanding was that parliamentary legal, had to come up with some sort of committee policy document, and then we were going to look at that and then formulate the changes out of that. So I don't know if that's happened at all, or if are we at stage 1 with the committee bill process? Because at that stage, my remembrance of it was that we said the executive bill is going to take too long, but now we have some form of a bill on the table, but it also only covers one aspect of the amendments. So it covers the Political Party Funding Act, and then it doesn't appear to cover the other areas of legislation that need to be changed. So my understanding again was that you'd possibly look at a general laws amendment bill, but then if you need a change to section 236 of the Constitution to include independence there, then that necessarily couldn't be made in the general laws amendment bill. So those constitutional amendments would need separate amendments. And then it's not only section 236, it's section 57 and 116 of the Constitution. So, Chair, I'm struggling to follow where we are where we are going. I remember us, and other colleagues can correct me if I'm wrong, sort of saying that perhaps the committee bill is the best way to go because of time. And if that's changed, we need to understand it now from parliamentary legal. I think we need to understand where are we in the committee bill timeline, where are we in the executive bill timeline, and where are those timelines going to end? And then secondly, do we need a general laws amendment bill? How does this proposal by this executive bill cover that? Do we need then do we need to have this bill, then a general laws amendment bill, and then another bill for the constitutional amendments? So that's another thing we need some advice on. And then it's also the discussion about, do we need to change section 236, 57 and 116 of the Constitution? And how will that process work and how long will it take? So Chairperson, I'm just pleading for this input so that I can just get an understanding. You know, I need to see the timelines. What are the different elements that need to be processed? In what kind of a bill will they be done? And then we can give input on, you know, the minister's policy on this and what did Parliamentary Legal Services come up with in any event in terms of a policy, etc. So that's my input on this, Chair. Thank you.
Okay, thanks, Honorable Roos. Honorable Roos, we have not, committee has not taken a decision on the committee or executive bill. And I think what you are raising will then, as Telana has highlighted, indicated that once we have taken a decision on either of the process to be followed, we'll then outline the time frame and the process that will be engaged. The last brief from the legal team, I think if you can recall, should be some
recording in progress.
So in the interim, before even the president ascended the Electoral Act, was to brief the committee on the possible time frame given the committee bill and or the executive bill. I think that was just a brief which was presented to the committee, but we'll come to that end once we've now solicited this decision, and the team will advise us, Telana, and also get the minister. I hope that he also has his own counsel. So we've not reached that decision. I think if I just to recap that this meeting, in fact, the two meetings that were rescheduled due to the cluster budget votes were attempting to resolve this question of how the committee is going to handle this important decision. Honorable Bongo?
No, thanks, Chair. And thanks for the presentations. I think we need to move with this process with the speed of a mirage, given all the time frames that we need to get to. It will appear now to me that the team of the minister that deals with the matter is at a serious advanced stage in terms of dealing with this matter. And my request is that if there are any other than the political party funding, if there's any other thing that we need to change, let's squeeze it within the process that the minister is busy with. And then we bring in the executive bill. I personally always had a problem with us having to do the bills from Parliament because of its administration and the cumbersome and the financial implications and so on. So if they come from the executive in the main, it is able to take care of all the administration of that act and the financial implications. So I'm agreeing, I'm supporting Honorable Pillay that let the executive bring the bill. Let us be provided with the time frames with which we need to deal with this matter so that they squeeze everything within there. With regard to the constitution, I'm not sure what legal opinion came, because from where I was sitting, we are now dealing with what we call consequential amendment to what we have already done. And I don't think a constitution need to be really tampered with at this point, but we stand to be advised because we have a team that is legal from Parliament. We also have a team that is legal from the minister's side. Then we can gauge on those issues. But if it will also be about the constitution, is not something that we can do now. Now I think we need to focus on the consequential amendments to enable the process that we have started to get through. So I support Honorable Pillay that we allow the executive to bring this so that we quickly and within the time frame deal with it. Thank you.
Thank you, Advocate Bongani Bongo. Honorable van der Merwe.
Yeah, thank you. Thank you, Chairperson. I think, well, good morning to you again and the colleagues on the platform. I think first and foremost, my view would have been that we should proceed with a committee bill because we were advised, as Honorable Roos had said previously, that this would be a quicker option in terms of us dealing with the consequential amendments. But the fact of the matter is, if Parliamentary Legal Services have not started the work on a committee bill, then maybe the issue of timeframes, then maybe it swings towards the executive bill of that, if that work has already started. Because at the end of the day, if we're doing a committee bill, we are the ones that should be engaging Parliamentary Legal Services for them to be able to start the drafts. I would also have been in favor of a general laws amendment bill so that we can quickly amend all the laws in one amendment bill, both the changes that we need to make to the ICASA Act and the Electoral Act. I also think that maybe at this stage we don't have to amend the Constitution and we leave it to 2024 after the 2024 elections. But I do want to make the point that even in the presidency, or it was a parliamentary budget vote, both the Speaker and Honourable Frolick took great pride in mentioning the Electoral Laws Amendment Bill and how the committee dealt with it, and they claimed the success of this process. So we really can't drop the ball now. And so I really would be convinced only if we ask ourselves if we want to do a committee bill or an executive bill. I would be convinced only in terms of which one would be quicker for us to put through the processes, because the election for all intents and purposes is now a year away. I've heard that Parliament wants to wrap up business quite early next year, so we need to keep all of those timeframes in mind. Then with regard to the document on the Political Party Funding Act that Adam had tabled earlier, I'm still going to take that document back to my caucus. But we did have a discussion as well in our caucus this Thursday, Chairperson, with regards to the court action that My Vote Counts is undertaking, where they want to force, obviously, changes to the Political Party Funding Act. For example, they want all private donations to be disclosed, effectively scrapping that 100,000 threshold. So those are some of the things we need to keep in mind. But I would go for a committee bill, but if the executive bill is already further away in the process and the executive bill will be quicker, then I think we need to go for that. But we need to be guided by legal services in terms of timeframes and which would be the best options. And then we need to take that decision and run with it. Thank you, Chair.
Thank you very much, Honourable van der Merwe. Honourable Modise.
Thank you very much, Chair. In light of the fact that we actually do not have time on our side, I want to agree with the members' views that now that the executive bill is far advanced, maybe we may need to consider it. I was also of the view that of having a general amendment where we are going to deal with all the other pieces of legislation that came from the electoral bill, which may need us to then look at into these consequential amendments. But if indeed the executive bill is at its advanced stage, it will take us another process, an administrative process of Parliament for a committee bill. So I do support the view that let us then continue with the executive bill so that we are able then to move with speed. What is we need to have a clear way forward on, Chairperson, it's on issue of timeframes. So the sooner we can be able to have a proper roadmap and a timeframe, the sooner we can be able then to move forward and deal with this bill. Thank you so much.
Thank you. Mr. Matonsi, is any other member I have not called? Okay. I'll invite the comments from the Telana Minister.
Should I go first, Chair, or should I wait for the Minister first? Or?
Yes, let me invite the Minister.
Sure.
Okay. Yeah, Honorable members, let me just once again take you through where we are now. In the last meeting which we held, I'm sure it's about 3 weeks ago or so, I presented to you 2 documents. The first document was step-by-step amendment of sections of the Political Party Funding Act, which, if you go back to the Electoral Amendment Act, the act now under consideration, which we have passed, which has forced us the consequential amendment. At the bottom of that, when we presented, we said the consequential amendment is needed for the Political Party Funding Act. We never put any other consequential amendment, and the committee did not raise it at that point, although we said if there's any other consequential amendment that is needed, we are amenable to it. So the drafters continued on the basis that the only part which needs to be amended is, which will need to be consequentially amended, is the Political Party Funding Act. And to that effect, they started the work, and I presented to you in the last meeting where I showed section by section the technical amendments that had to be done. And in my understanding, the committee adopted those because nobody challenged them, because mostly they were technical, like where the Political Party Funding Act said political parties, we just add independent representative or independent candidates, as the case may be. We went on doing that, and we finalized it right up to the end of the Political Party Funding Act. Then the next document I presented to you was policy approach to the Political Party Funding Act consequential amendments, the overarching principles of what we need to do, because there are certain things which needs to be done, which are not technical, which are substantive, like the issue of limits of reporting donations, limit for reporting international donations, domestic donation and international linking fiscal allocation to representative parties to limits, etc. And more importantly, changing the formula for allocation of funds to parties and independents in Parliament, because as you may be aware, when the Political Party Funding Act was passed, there were no independents, and we were allocating money in terms of the strength of a political party. We all know that an independent candidate is one person. And so what formula do we apply to them? I presented in the policy document I presented to you, we were proposing that everyone who wins a seat gets 0.25% of the funds per every seat. That means every seat ends to 0.25%. In that way, we thought there will be equity and equality between political parties and independents, because you are getting money 0.25% of all the funds that need to be allocated. That is the main issue. These are the main issues I want to hear from you. And political parties said, because we gave them this document very late, we need to give them chance to go to their political parties to consult. And today we are waiting for the results of those consultations so that the team can go on and finalize. If you do that today or sooner rather than later, the drafting team will be able to incorporate these changes into the technical amendments which have already been made. Basically, that's what one was expecting today, Chairperson. Now, moving to the other areas that needs to be amended, I subsequently learned, as we said, we are open to proposals. I subsequently learned, especially from the IEC, that one, we need to consequentially amend Electoral Act 73 of 1998, the very same act for which we're taken to court. We need a consequential amendment in that. In the previous act, which we never amended yet, is the issue of after coming with the issue of 2 ballots, we never amended what will then happen to an individual who vote outside the province. Basically, to me, again, it's a technical thing. It's not really a substantive. It's just to say, in the past, when you vote outside your province, this used to obtain. You'll remember, if you vote outside your province, you forfeit the provincial vote, but you gain the national one. Now that things have changed, what do we say about such individuals? That is the amendment that needs to be added. And to me, the committee just needs to make proposals, and we go and put that amendment. And I still believe it's definitely technical. The second one is the Electoral Commission's Bill, the bill that established the IEC. It needs to be consequentially amended, simply because when the bill was enacted in 1996, there were no independents, and the bill keeps on talking political party. So to me, it's just again an insertion. You insert political parties and independents, because independents will have to participate in the party liaison committee. And the party liaison committee issue is in the Electoral Commissions Act of 1996. So to me, again, it's sort of some form of insertion, just to make sure that independents are accommodated. Then the third one is this issue of electoral community. What do you call it, Alan? Is it the communications bill? What do you call it?
Electronic communications.
Yes. Is it electoral communications?
Electronic Communications Act.
Yes, electronic, yes. Electronic communications, in that the Electoral Communication Bill allows members of parliament, allows political parties to be covered when they are running an elections campaign. It regulates the manner in which they are covered in terms of communication. Again, it's just technical, that we're covering political parties, not independents. And I'm sure you are aware, independents will also need to have media coverage in the same way, especially electronic media, especially the public broadcaster. Everybody will demand to have a cake of the public broadcasters' communication to the public when they run their campaigns. And it so happened that technically it's only political parties which were regulated on how much time do they get, which events do they get covered, etc. Now we just need to include independence there. Now, all those tell me that it's not a lot of work that's awaiting, if you agree that these are the three areas that needs to be amended. Only one is outside the realms of this portfolio. That is electronic communication. It's a part that doesn't fall under Home Affairs Department, and maybe we stand to be advised on what to do. Now, the other amendments, which I want us to deal with once and for all and finalize, mentioned by Honorable Ruos, and I remember he also mentioned them in the previous meeting, are the issues in the Constitution. He mentioned, and I'm speaking under correction, Honorable Ruos, please correct me before I continue stating a wrong thing. I thought you said section 56, section 117, and section 236. Am I correct, Honorable Ruos, before I continue?
Minister, it's 57 and 116. It's in your policy document.
57 and 116, not 117.
No, 57 and 116.
Yes, I'm not very sure, because, okay, let me start with the easiest. Section 236. Honorable members may remember, I'm the one right from the beginning, 2 years ago, when we started this amendment, who thought section 236 of the Constitution need to be amended. And there's not a single lawyer up to so far who agreed with me. From all walks of life, they were saying the Constitutional Court judgment demands no amendment to any part of the Constitution, and any part of the Constitution can be entered into. I then tried to seek clarity, even though it was not in writing. And if you read section 236, 236 says, to enhance multi-party democracy, national legislation must provide for the funding of political parties participating in the national and provincial legislatures on an equitable and proportional basis. Now, that is the Political Party Funding Act, which has been done in line with this part of the Constitution, and which we did in 2018, and then it came into operation later on, in line with this section 236. Now, when we now amend this Political Party Funding Act, which is in front of us, we are including independence, and the argument from what I've heard from lawyers is that that section 236, which says a national legislation must provide for funding, there is nothing that excludes independence. At least I was told so. They say it does not. The fact that it mentioned political parties does not say independents cannot participate. And that's why in the amendment, we kept on inserting independent candidates, independent representatives, etc., etc. So in that regard, I agree with those who says we don't need to amend that part of the Constitution. Now that leaves us with section 57. I'm not sure, Honorable Rios, when you say it's in our documents, which one do you mean? Do you mean the one we presented some 3 weeks ago, or which document? Because I don't remember that. Please just remind me.
Minister, yes, it is. It's the one we received a few weeks ago. It was titled Draft Policy Document with IEC Comments, but it didn't have a date on it.
Draft policy document with IEC comments.
Yes, so the heading.
Oh, yes. Now I know what you're talking about. Yes. You'll remember that before that meeting started, we wrote a letter to withdraw that document, Honorable Rios, because I said it was sent here without the approval of myself and the deputy minister. We withdrew it. And in withdrawing it, I presented these two documents to you under discussion now. So that document is not on the table. And I said we are withdrawing it because I cannot own it, because I did not understand some of the issues that are mentioned in there, including amendments of the Constitution. So I thought the committee understood that that committee is off the table because it has been withdrawn. If people want to bring the matters in that document in a different way, they must bring it, but not the document itself, because we withdrew that document. And specifically, Honorable Rios, we withdrew it because we did not understand that any part of the Constitution need to be changed, because right for the past 2 years, all the lawyers were in agreement. The only area where there are many different opinions, I mean, there are some sort of different opinions of lawyers, as you know, they always do, is section 236. The majority say you don't have to touch it because it does not specifically exclude independence. Others say just to be on the safe side, to be sure, and to avoid litigation, we need to be very clear. We need to put the word independent there. But the general agreement was that we don't need to change any part of the Constitution to do what the Constitutional Court has instructed us to do. So in summary, honorable members, the part of the Political Party Funding Act that needs insertion of independent candidates and independent representatives has been done. I presented that to you, unless the committee wants to change it. But on the day we presented it some 3 weeks or so ago, nobody challenged it. So that part is done, is finalized. The part that needs to be done on the political party funding are these areas of principles of formulae or limits, and how do you accommodate independent candidates in terms of accounting, because you can't expect a sort of similar principles from them as the political parties, etc. That is what we are waiting for today. Then the areas about the insertions again on Electoral Act 72 of 1993, the elections, 1998, the Elections Commission Act of 1996 and the electronic communication. We will insert them immediately if this committee agrees, and I don't see why this should take a very long time. Thank you, Chairperson.
Thank you very much. Telana?
Thank you, Chairperson. So I've sort of noted 3 questions. The first being, what has legal services done regarding the committee bill process? Chairperson, as you pointed out, a firm decision or resolution wasn't taken by the committee on whether to do a committee bill or an executive bill. And in terms of Rule 268 and 273(1), the committee would then have to first, after it made that decision on whether to do a committee bill, request permission from the House to draft a committee bill. So the work done by legal services so far was to assist the committee secretary and the content advisor with that memorandum requesting for permission. We had done the research in terms of what we thought needed to be amended and whether a decision to do a general laws amendment bill. We assisted the committee secretary and the content advisor with that memorandum. The memorandum was then drafted. However, only when the committee took the decision to draft a committee bill, we would have then submitted the memorandum to the committee for them to approve that memorandum for permission. Secondly, the second question I had was whether the committee bill process was quicker. Following, if the committee had decided whether we would then proceed with the committee bill and we had been granted permission to draft that committee bill, it would have taken legal services 6 weeks to draft the committee bill. However, if the executive has a bill ready gazetted earlier than 6 weeks, obviously an executive bill would then be much quicker. And then the third question I had was regarding a constitutional amendment and whether that was necessary. We haven't been instructed to provide an opinion on whether that is necessary. And in any event, if a constitutional amendment is decided by the committee, that would be in a separate bill. It cannot be in a committee bill. It cannot be in an executive bill. It would need to be in a Section 74 standalone bill, because that's what Section 74 of the Constitution says. And then my last comment was that there is precedent for a general laws amendment bill across departments. We've seen it in the Anti-Money Laundering and Combating Terrorism Finances Amendment Bill that contained legislation that was from the Department of Justice, the Department of Social Development, the Department of Finance, Trade and Industry, and that was contained in one general laws amendment bill. So there is precedent for that. Thank you, Chair.
Thank you very much. I see, you have comments on the issues you want to introduce to the committee?
Thank you, Chairperson. I have followed the discussion closely. I think 3 of the 4 issues that have been raised, in other words, outside of the electronic communications bill, we agree with, and we will engage on those issues at the appropriate time. I thank you very much, Chairperson.
Okay. Thank you, Commissioner Miepza. I think it is clearer that the process led by the minister is already underway in terms of the revised bill. And the members of the committee appreciate that we need to move faster. And I'm happy that Telana also reaffirmed that if it will take less than the period you have indicated if we took the committee route. And members further agree that we need to close up all the processes that needed to be attended by the committee. We'll take a view which is gathered by yourself, members, that we must proceed with the executive bill. And the minister and the stakeholders, his councils and the IEC, including even the Parliamentary Legal Services, must assist the process so that we are able to speedily conclude this process and reporting to Parliament. Now, the IEC needs to present to the committee in the next committee meeting, as Commissioner Miepza has indicated, areas which are consequential for the committee to attend to, and those that the ministers already presented in the last committee meeting with the party political funding and the principles that have been presented. I get a sense from Honorable van der Merwe that, and I think overall in principle, this affirmation of that principle that we need to adopt the principle that was laid by deposited by the minister. But I get from Honorable van der Merwe that they have not interacted with that, and she requests that she be given time to go back and look on that matter of the principles. But I think this meeting appreciate the process and the framework that is laid, that we can work on in the process. Minister, which means therefore that the time frame is important on and when we're going to conclude, including other areas that the IEC has indicated or Telana has indicated, so that we don't work against the time frame of the IEC. I know, or all of us will know, that we have been cautioned in many times that we process delayed impact negatively, or it will impact negatively to the standard work or processing planning of the Independent Electoral Commission. So that will assist us to move forward on which we this meeting takes, that will move with the executive bill as is already underway, and there's an indication of progress to that front. We will again request members that we've requested Mr. Matonsi to request from the House that our meeting must end Tuesday and Friday to interact and complete this matter, because all of us were termed on urgency to conclude this process. So we have requested that point and hope that we'll be able to be assisted by all the stakeholders involved to deal with this matter. Is there any other matter outside our process moving forward, colleagues?
Chairperson.
Honorable Ross.
Thank you, Chair. Yeah. So, I think we had sort of three decisions to make, and certainly if it's an executive bill, that's fine. If there's a commitment that we will be able to do the drafting within 6 weeks, and that will be a general laws amendment bill and will cover all of the consequential amendments. That is my understanding of what we're saying, and then that sounds fine. I would just like to ask then that on those constitutional amendments that we please do request from Parliamentary Legal Services a legal opinion on whether we need those constitutional changes or not. Because I hear what the minister's saying, you withdrew that document, but it doesn't mean that those things are not under consideration. So if I look at section 57, for example, it's talking about, financial and administrative assistance to each party represented in the National Assembly. So it doesn't exclude independents, but it doesn't include them either. And I think it would be worthwhile for us to just get that legal opinion from Parliamentary Legal Services as to whether a Section 74 standalone bill is then warranted. Because even if that process is then agreed that it needs to happen, the minister suggesting that he believes it doesn't need to happen immediately, but it doesn't mean that we can't agree as a committee that it should or shouldn't happen.
Okay. No, and I think that will take that. Telana, note that I think in our next, you'll process that legal opinion formally to the meeting. I see the hand of Honorable Luzel and Honorable Pile. Honorable Luzel.
Yeah, thank you very much, Chairperson. I'm traveling now, so I hope I'm still clear. But I've got a similar comment to what Honorable Ruiz had just asked. So we are saying that we support the minister to proceed with the executive bill if he's able to do so within a 6-week period. He did say it shouldn't take very long. But my question then is, he's gonna, obviously within his ambit, he is amending, he's bringing changes to amend the Political Funding Act, the Electoral Act, the Electoral Commissions Act. But then is he proceeding with the General Laws Amendment, General Laws Amendment Bill to include the changes to the Electoral Communications Act? Or are we as a committee able to refer those changes that needs to happen to that act to the Communications Committee? So I just wanted to have clarity on that, Chairperson. Thank you.
Okay, Honorable Pillay. Okay, Telana.
Yes, Chair. Yes, Chair.
I was saying that the matter of Honorable Ross that has been raised, we should note it for legal opinion in relation to the section, and we request you to, or the Parliamentary Legal Service, to give an opinion on that.
That's fine, Chair.
Yeah, so we'll
We
request
can
that.
do that for you.
Yeah, that in the next meeting. Minister?
Yes, Chair.
Yeah.
I don't want to argue with Honorable Ross. I think we have already made the ruling that we'll go and consult. But
Yes.
I also want party, us as leaders, not just to come and consume anything because it's said by lawyers. If you look at section 57, one of the reasons why I withdrew that document, I did not agree that section 57 excludes independence. The areas that Honorable Ross is talking about and that document was referring to is section 57, subsection 2B, which says the participation in the proceeding of assembly and its committees of minority parties, simply because there's a word minority party, they believe then it excludes independence. The second one is section 57, subsection 2C, which says financial administrative assistance to each party represented in the assembly. Now, when people sit together in negotiations, they are called parties, conference of the parties, like in climate change. It does not necessarily mean exclusively a political party. Then it says assembly in proportion of representation to enable the party. Then lastly, it says the recognition of the leader of the largest opposition party in the assembly as the leader of the opposition. What do you amend there? Because there's no way an independent will ever be the largest opposition in parliament. So when you look at it, we will go and ask for legal advice, but I don't think it needs to be amended. Now, 116 is exactly the same issues, but pertaining to the province, where the National Assembly is just replaced by province, but they mention exactly the same thing on section 1162C and 1162D. So I think we'll look for that legal opinion, but definitely independents are included here because they are called parties, not political parties, but they are parties. They are parties to deliberations in the assembly. They are parties to deliberations in the province. I just wanted to clear that. There are two other issues I want to mention, Chairperson. The other has already been mentioned by Co-Chair, Honorable van der Merwe, about the electronic communications. Yes, I want guidance before this meeting ends. What do we do with that? Because the others will definitely do. It's just in sessions. The other two areas that needs amendment. So I need guidance from the committee. What must we do about the Electronic Communications Act? Please guide me on that one, Chairperson. The last issue I want to mention, we've received applications from two political parties, but we have not yet heard from the court. Not from two political parties, excuse me, let me withdraw that. From structures, two sort of structures. The first one is my vote count, which have applied to court to challenge the Political Party Funding Act. This very act we want to amend. Even before we amend it, they are challenging the version we want to amend. And they did so after I presented these principles I don't know whether they were preempting or what, but they are challenging the act as it was passed then, which has been in operation for all that period under which it has been in operation. They are challenging it. So as we amend, we must understand that what we are amending is already being challenged in court. The second application is the Association of Independent Candidates, who have also applied to court to challenge the Electoral Amendment Act, this very act which the president assented to, which has now made us to sit here and discuss consequential amendments. They are challenging it, but in my understanding, when I read all the documents in the applications, they are challenging only one part. They are asking the court to insert, they are asking for insertion also, to insert by substituting 350 for 200, and by also substituting 50 for 200. Let me explain. They want the judge to substitute 350 for 200 on the first ballot. You remember that the ballot from the regions, we said 200 seats will be 14 regions. We also said the other 200 seats are compensatory seats that will be fought nationally. Now, the Association of Independents in their application say the regional seats, which must be fought, must be 350, not 200. And the compensatory seats belonging to political parties must only be 50, not 200. And they are saying the judge needs to insert that. If the judge inserts that, then they believe the bill is okay, from my understanding of what I read. So I just wanted you to know, not that there is anything you will do today, because we'll hear from the court, but I just wanted you to have that type of information. Chairperson, I still need guidance on these electronic communications. Once that is done, then we are on the move. Thank you very much.
No, thanks, Minister. My understanding on the electronic amendment process, and IEC will assist me to capture it correctly. It appears that this amendment needs to be interacted with ICASA. And the IEC will be in the engagement in that front on the amendments. I think that is an area which I've captured. Unless I've captured wrongly, Commissioner Miebza, you'll probably rescue me. But in my understanding is that part of the consequential amendments that the IEC will be presenting to the committee and also includes ICASA, that will exonerate the point that you are raising, Minister. Can I get a sense on that area, Commissioner Miebza?
Thank you, Chairperson. As the commission, we have an appointment, a scheduled appointment with ICASA. We know, or we understand that their regulations must now accommodate independent candidates. But as to how they are proceeding with the parliamentary process, that's exactly what we would want to establish with them. And once we have done so, we will indeed advise the committee of that process.
Okay. No, thanks, Commissioner Miebza. I think, Minister, you are fine with that point?
Absolutely, Chair. Absolutely.
Okay. Members, there are 4 areas which we must we're agreeing on. We've taken a decision to proceed with the executive bill. 2 will allow the legal opinion in relation to the matter Honorable Roos has raised. Both the Minister and Telana Parliamentary Legal Services have undertaken to work on that front and come back to the Portfolio Committee in the next meeting. Secondly, is that the principles which were outlined or presented to the committee by the minister in relation to how we must deal with the party political funding will, with the request of Honorable Van der Merwe, that she still has to interface with the political or the caucus, will grant that. And in the next meeting, will then take a decision to approve. But in principle, there's an appreciation that we must work with that framework. We may need to have inputs on members so that we move all of us in the same pace. We'll then also allow the IEC in the next session to also present consequential amendments or areas of interest that we need to interact with, which I think Minister has outlined in his notes, and also Telana in her notes, so that we're able to begin to framework on the issues that we must deal with. Minister, in our next meeting with your council, we need a time frame on how we're going to deal with this process of the executive bill, as the period has already been highlighted, and the IEC will also assist us. And now that they're going to engage with the ICASA, and out of that process, we'll be able to interface with that. On our part, with the Parliamentary Legal Service, we'll also interact with the Committee of Telecommunication, the Chair Maneli. We've already ensured that bilateral in terms of this process that must be engaged by the committee. Then that leaves us in that matter. That summary assists us to understand how now that we're going to deal with this amendment, and all the stakeholders, including IEC, Home Affairs Minister, the Council, ourselves, and Telana, to ground our focus on the issues that were raised. What will be important is that once clarity on certain areas by both the legal teams, committee deliberate on and take a decision, and we move forward. I think that will assist us, colleagues, collectively, in terms of the framework. Is there any other point, members?
Yes, Chair.
Honorable Mtwaledi?
Yes, there is. Chairperson, by the time we come to the next meeting, the legal team will have determined the time frames. In fact, I must even bravely say they might have already finalized the amendment, because they are just in sessions. So they can give you a time frame, or they will have finalized. What they can't give you is the time frames on these principles, because we have still given time from the proposition of Honorable Van der Merwe to go back to parties to consult. They can't give time frame because they don't know what the parties are going to say. We have put the principles here. If they are accepted as they are, we will be able to make time frames. But because we don't know what changes will political parties propose, it will be difficult to make time frames. So for that part of this bill, we can only give you time frames after political parties has given us their input. But the time frames about what has been agreed on, which needs to be amended, that one will be able to determine, or we might even come to the next meeting having already done that, because it's not a lot of work. I just wanted to sensitize you on that one. Thank you.
No. Thanks, Minister. I think it's fair enough. We'll also interact with Honorable Van der Merwe, so that at least in our next meeting, we conclude this process. Members, is no any other matter? Mr. Matonzi?
Yes, Chairperson, there's no any other matter except that you indicated that no, I need to apply for the committee to meet during constituency for Tuesdays and Fridays. There was a memo from the House Chair that by Monday I should be in a position to indicate which dates and also what I'm going to be dealing with. So if we don't have time frames by now, so it will be difficult to know when is the department going to table the bill in Parliament, so that we can have those programs for the processing of the bill.
Okay, noted. Let's deal with that one. It's an administrative matter. We can work outside the meeting. Yourself and I and the content advisor.
Okay. Otherwise, there's nothing, Chair.
Okay, Commissioner Miabza?
Chairperson, there is nothing from us. Thank you very much indeed.
Okay. Thanks, Minister, DM. Thanks, honorable members. Thanks, Commissioner, and all the team, the executive and members. We have outlined how we must move forward, and we'll then meet in our next committee meeting. The meeting stand adjourned. Thank you very much.